Distinguished delegates, ladies and gentlemen, it is my great pleasure to welcome His Excellency Mr. Didier Reynders, European Commissioner for Justice, who came on the occasion of the MLA Diplomatic Conference to mark the EU's 8th Day Against Impunity. We are honored, Mr. Commissioner, that you will address the audience, and please let me invite you to take the podium.
Well, thank you very much for your invitation, not only to the podium, also to the conference more broadly. And I want to say, dear ministers, dear Dominika, dear Gunnar, dear Secretary of State, dear Marko, dear Prosecutor General, I know that we'll have to listen to dear Kostin, dear Andriy Kostin, and also to the Prosecutor of Bosnia and Herzegovina, dear Milanko. Thank you also for your presence, and dear Matthews, chair of the Genocide Network. But, ladies and gentlemen, more than 20 years ago, the preamble of the Rome Statute affirmed the primary duty of every state to exercise its criminal jurisdiction over the most serious crimes of concern to the international community. Today, with Russia's illegal war of aggression against Ukraine, the world is confronted with the largest international armed conflict on the open continent since the Second World War. Grave human rights violations continue to occur on Ukrainian soil on a daily basis, with many people, amongst which an important number of children, becoming victims of atrocities that deeply shock the conscience of humanity. In the past year, I was myself in Ukraine on numerous occasions, where I witnessed firsthand the appalling situation on the ground. We shall not tolerate a culture of impunity, which threatens the stability of the international legal order and leads to a vicious circle of violence and human suffering. If we are all here today, it is because we are determined to reaffirm that the prosecution of international crimes remains at the forefront of the global struggle against impunity in these challenging times. Today, I have the pleasure to celebrate with you the 8th EU Day Against Impunity within the context of the negotiations of the Convention on International Cooperation in the investigations and prosecution of genocide, crimes against humanity, war crimes, and other international crimes. As the synergy between these two initiatives demonstrates, an enhanced international legal framework to investigate and prosecute international crimes is essential to address the challenges to the current accountability landscape in diverse conflict-affected areas. In this landscape, the war in Ukraine has been a dramatic game changer, which has led to unprecedented levels of international commitment to fighting impunity. The Union has taken a strong and resolved stance in this regard. Within my portfolio as European Commissioner for Justice, I have made the fight against impunity for alleged international crimes committed in Ukraine a top priority of my mandate. The Commission has been dedicated to supporting the 16 member states that have so far opened national investigations into international crimes committed in Ukraine. 6 of these member states formed a joint investigation team together with Ukraine and the Office of the Prosecutor of the International Criminal Court as participants. And we have more and more contact with Europol to do the same, and we have an MOU with the Department of Justice of the US to have a good collaboration also with such a team. Furthermore, upon proposal of the Commission, the Eurojust regulation was amended last June with the objective to support the Prosecutor General's office with the preservation of crucial evidence. And I have discussed today with the President, Vladislav Amran, of Eurojust, to see the progress in the way for Eurojust to take part in such a process. On 15 February, the members of the Joint Investigation Team announced to have extended the scope of their respective investigations to the crime of genocide, in addition to investigations related to war crimes. These efforts are coordinated by Eurojust, whose mandate has been strengthened to set up a core international crimes evidence database, enabling to secure storage, preservation and analysis of evidence of international crimes committed in Ukraine. This database will be fully operational in the next months. In addition, the European Commission has also provided the Ukrainian Prosecutor General's office with €4 million worth of EU funding to allow for the implementation of a new electronic case management system, as well as a swift upgrade of the office's war crimes platform. In addition, we have provided €2 million worth of equipment to regional prosecution offices. Moving forward, we will continue as a European Commission to do our utmost to ensure the proper investigation of international crimes and prosecutions of their perpetrators by the Ukrainian Prosecutor's Office. We also have strengthened our cooperation with international actors, including the ICC. It is clear that when it comes to preventing impunity for the most serious crimes committed during the war, the ICC remains the key international actor to investigate and prosecute the perpetrators. For this reason, that since the beginning of Russia's war of aggression, the European Commission has provided over €10 million in support of the ICC's work on Ukraine. And you know that we ask Ukraine to ratify the Rome Statute. On the crime of aggression, there is a common understanding in the European Union that such a crime must not go unpunished. In November 2022, the Commission and the European External Action Service presented a series of options to prosecute the crime of aggression. However, a common position is still to be found on the options of an international ad hoc tribunal or an internationalized or hybrid tribunal. While discussions on a dedicated tribunal are ongoing, the Commission simultaneously encourages reflections on strengthening the ICC's jurisdictional regime over the crime of aggression through an amendment of Article 8 bis of the Rome Statute, and thanks the Member States having taken part in such a process to extend the mandate of the ICC. In the short term, the establishment of any potential accountability mechanism for the prosecution of the crime of aggression in Ukraine should respect the ICC's mandate and jurisdictional primacy. As a first important step towards ensuring accountability for the crime of aggression, discussions are progressing on the setting up of the International Centre for the Prosecution of the Crime of Aggression in The Hague, which will be attached to the existing joint investigation team that I have mentioned. It will provide a standing structure of enhanced coordination on the collection, preservation and analysis of evidence related to the crime of aggression for any future trials. The ICPA will support the national investigations carried out by some member states for the crime of aggression. I'm very happy to announce here today that the ICPA will take up its work by this summer. More broadly, that in the context of the ongoing war in Ukraine, we have launched several initiatives to promote accountability, including by broadening the mandate of Eurojust and further supporting the crucial role of the Genocide Network. It is important to build upon this momentum in the spirit of complementarity by further strengthening both our national and international capacities in bringing alleged perpetrators of these crimes to justice. This is especially important because the nature of international crimes and their cross-border effects, suspects, witnesses, evidence and assets relating to these crimes are not limited to the national territory of one state, nor to the territory of the Union. An efficient interstate cooperation is therefore crucial to avoid the creation of safe havens for perpetrators of mass atrocities. The successful outcome of effective investigations and prosecutions of crimes at the national level thus depends on the close cooperation among various competent authorities as well as on the integration of international obligations into national laws. For instance, besides defining the criminal offences, another key element for the successful prosecution of core international crimes is the adoption of legislation that supports the exercise of universal or extraterritorial jurisdiction. The setting up of a multilateral treaty on mutual legal assistance and extradition would only further strengthen and facilitate the cooperation among member states investigating and prosecuting these crimes by ensuring that their authorities coordinate their actions and have access to crucial information. I therefore applaud the work that has been conducted by the MLA Initiative Core Group in bringing forward this proposal. Let me also use this opportunity to highlight that the Union facilitates the fight against impunity through the implementation and development of an effective cooperation system, which puts at the disposal of national authorities various tools to better coordinate their investigations and prosecutions, such as those offered by Eurojust again. The Genocide Network operates in close synergy with Eurojust in line with their respective mandates. Eurojust and the Genocide Network support national authorities of the Member States in the investigation and prosecution of core international crimes and facilitate cooperation with international bodies and civil society organizations. While Eurojust provides operational support to ongoing investigations and prosecutions, the Genocide Network offers a cooperation forum where the main accountability stakeholders interact to exchange expertise and best practices. Civil society organizations, in particular those specializing in open source investigations and the documentation and litigation of core international crimes, are crucial partners for national authorities in the fight against impunity. On the 21st of September 2022, Eurojust, together with the Genocide Network and the Office of the Prosecutor of the ICC, published guidelines to assist civil society organizations to collect and preserve information related to international crimes and human rights violations. Let me conclude by stating that all these initiatives illustrate how we are progressively building a global and multi-layered criminal justice system together to prevent atrocities and guarantee lasting enforcement of international justice. I would like to use this opportunity to commend all of you for your work and commitment in this regard. I am fully convinced of the added value of the joint efforts in working towards a future where impunity will be a feather of the past. We have, at the Commission level in the field of justice, two main goals. The first one is to bring all perpetrators of international crime to justice, and the second one is to be sure that Russia will pay for the reconstruction of Ukraine and the reparation or compensation of the damage caused by the Russian aggression against Ukraine. I'm sure that your work will help to do that with different good cooperation between national authorities in the prosecutions of international crimes. Thank you very much for your attention, but thank you also for your work.
Thank you, Commissioner. With the official opening of the 8th EU Day Against Impunity, I would invite Madam Dominika Švarc Pipan to offer welcoming remarks.
Good afternoon, Excellencies, ladies and gentlemen, dear colleagues. Thank you, dear Commissioner Didier, for such insightful and also encouraging words. It is a great privilege, I think, for all of us, and particularly for Slovenia and other members of the core group of states initiators of the MLA conference, that this diplomatic conference aimed at the final adoption of the text of this new convention intended for prevention of impunity for core international crimes coincide with the commemoration of this year's EU Day Against Impunity. Once adopted, I have no doubt that there will be a successful adoption of this convention. The convention will be yet another and a very important piece in the puzzle of the ever-evolving and improving system of cooperation, of international cooperation and mechanisms aimed at outrooting impunity to the maximum possible extent. Allow me to also say that I consider it a great personal privilege to be able to address you at this opportunity of the EU Day Against Impunity, as I have devoted most of my professional career, both academic and practical, to the fields of international human rights law and international criminal law, including a very short period as a counsel at the Office of the Prosecutor at the ICTY. I therefore have at least a slight, or maybe a slightly different, experience and understanding than many politicians into what it means to have a successful cooperation and successful tools in investigating and prosecuting the most serious international crimes. And I also share the Commissioner's warm thank you for all your effort and all your work. So I'm deeply deeply honored once again to welcome you at this diplomatic conference, and I would also like to express a warm welcome to our wide audience online that is following this important event. The rich agenda ahead of us, with a panel that will be sitting in these seats shortly, filled with distinguished speakers, will surely provide further important insights on various aspects of fighting impunity on national, regional and international levels. And so I thank you, all of you, to be here today and to be willing to participate in this important discussion. It is not just the situation in Ukraine which has surely highlighted the importance of the efforts such as the MLA initiative, which is dated more than a decade ago, but it is also other wars in our immediate neighborhood that are not yet so distant that remind us of the importance of these efforts. Less than 30 years ago, wars following the breakup of Yugoslavia raged in our neighborhood and in our country, and the consequences still remain to be seen today. As we finally started to believe that peace has firmly grown in Europe, a new war of aggression in Ukraine erupted. So we must never rest, and we must never believe that we have outrooted men's inhumanity to men. We must always work towards preventing, but in cases of commission of crimes also towards addressing and prosecuting those most horrible moral and legal crimes. As we know, and as the Commissioner also pointed out, it is primarily the obligation of every country on a national level to prosecute these crimes. European countries sure are the front runners in this respect. Great development, we can say, has been achieved. Many European countries, as the Commissioner pointed out, there are 16 of those, including Slovenia, are already investigating these cases on a national level. In the upcoming panel, I was informed that we will hear the experience of Germany and Sweden, but we should not forget other jurisdictions that are investigating and prosecuting these crimes: the Netherlands, Belgium, Finland, France, Lithuania, Slovakia, to mention just a few. We will also hear how the European Union and Eurojust are supporting national efforts and how Europe is contributing to the global effort of the fight against impunity. During the rest of the afternoon, we will also learn about the European perspective on fighting impunity, but many of the presented practices and experience that we will hear from the European colleagues here on stage are surely applicable to other regions as well. And we are particularly happy to not just have countries from all regions and continents of this world being in the core group initiators of the MLA Convention, but also many of the delegations from all across the world here with us today and during these 2 weeks. It is almost a cliche, but nevertheless very true, that it is only when we as nations, as an international community, work together, we will be able to better ensure accountability for the horrible crimes committed. We will be able to ensure justice for victims, and we will be able to prevent or at least minimize the risk of further violence and further atrocities. It might sound naive, but I also believe, and I believe that we share that belief, it is true. Together we can make the world a better place. And while I'm being nostalgic and maybe romantic and maybe naive, but I believe that it is a dream worth sharing, let me finish with a quote by Edmund Burke that I believe sums it up all perfectly. The only thing necessary for the triumph of evil is for the good men to do nothing. So thank you, dear delegates and representatives of countries all around the world, for being those good men that do not want to not do anything, that you want to do something and that you want to do the most you can together with the rest of us to make another step towards the world where impunity will no longer be an option. Thank you very much, and I wish you a pleasant afternoon.
Many thanks, dear Minister, for your inspiring words. On behalf of Swedish presidency of the EU, we'll hear from Mr. Gunnar Strömmer, Minister of Justice of Sweden, via video address.
Excellencies, distinguished guests, ladies and gentlemen. As a representative of the Presidency of the Council of the European Union, I am delighted to speak to you today on the occasion of the 8th EU Day Against Impunity. This is an important yearly event to raise awareness and share experiences of the efforts made in the European Union in the fight against impunity for the crimes of genocide, crimes against humanity, and war crimes. The importance of this event is even more evident when we once again see a war taking place on the European continent. Sweden and the EU condemns in the strongest possible terms Russia's war of aggression against Ukraine. Supporting efforts towards ensuring accountability for the crimes committed in Ukraine is also one of the priorities of the Swedish EU presidency. But we should not lose sight of the fight against impunity also in other parts of the world. Gathering today under the topic of stepping up to the fight against impunity, national, EU and global response, highlights the importance of a multi-layered approach to effectively fight impunity. Sweden has a long history of commitment towards ensuring full accountability for the most serious crimes of concern to the international community. And one of the aims of today's occasion is to share experiences and best practices. I would like to take the opportunity to highlight 3 important points from Swedish experience, focusing on the efforts at the national level. First of all, to strengthen investigations and prosecutions of core international crimes we have since long established independent specialized units within our prosecution and law enforcement authorities. This is a proven, effective measure in the fight against impunity. To date, we have final judgments from Swedish courts on core international crimes committed in Rwanda, former Yugoslavia, Iraq, Syria, and Iran. Furthermore, structural investigations into crimes committed in Syria and for the situation in Ukraine are ongoing. Secondly, national prosecution is dependent on well-functioning international cooperation between states, but also with the International Criminal Court and other international organizations, including organizations such as UNITAD and IIIM. Cooperation with civil society is another important factor. As a supporting state to the MLA initiative, I am glad that today's event could be held in the margins of the negotiations of this new convention, with a specific aim to strengthen judicial cooperation in the fight against impunity for the core international crimes. At the EU level, we have developed a broad toolbox of instruments for judicial cooperation that strengthens investigations and prosecutions by national authorities. I would in particular like to stress the role of Eurojust and the Genocide network in facilitating cooperation and exchange of knowledge and best practices between practitioners in the EU and beyond. I hope this will inspire similar initiatives also on other continents in order to further strengthen the global fight against impunity. Thirdly, necessary legislation must be in place when it comes to criminalization of core international crimes and to establish jurisdiction for these crimes. Sweden is a strong defender of the principle of universal jurisdiction for core international crimes, and our national legislation is built on this principle. Thank you for giving me the opportunity to share a few of my thoughts with you as an introduction to your discussions, and I hope you will find the discussions today very fruitful. Lastly, I would like to express my gratitude to the co-organizers at the Genocide Network, Eurojust and the Commission for their incredible work to make this event possible. A big thank you also to our friends in Slovenia who so graciously have hosted this year's event in connection to the diplomatic conference taking place in Ljubljana. I wish you all the best in these negotiations. Thank you.
Many thanks, Minister from Stockholm. And our next speaker in relation to welcoming remarks is Mr. Marko Štucin, State Secretary of the Ministry of Foreign and European Affairs of Slovenia.
Thank you very much, Mateusz. Dear EU Commissioner, dear Ministers, distinguished guests, ladies and gentlemen, it is my honor to welcome you all at the EU Day Against Impunity event here in our beautiful Ljubljana in Slovenia. Today we are gathered here to highlight the importance of ensuring justice for all victims of atrocities and to renew our commitment to end impunity for international crimes. The theme of this year's EU Day Against Impunity is particularly topical in light of recent events that have revealed the urgent need for international justice. We must continue to work together to ensure that those who have committed atrocities are held accountable. Ending impunity is crucial, first and foremost for the victims of atrocities, as it provides them with a sense of justice and helps them to overcome the trauma they have experienced. We must also ensure the victims have access to legal aid, protection and compensation. We cannot allow impunity to persist, as it undermines the rule of law and perpetuates the cycle of violence and conflict. As we have witnessed over the years, ensuring accountability and delivering justice to victims is essential for achieving long-lasting peace and reconciliation, promoting human rights and preventing the atrocities. The cornerstone of our efforts is to build a world where human dignity and justice are respected. Ladies and gentlemen, many years ago, the international community made a promise by saying, "Never again." In order to keep this promise, it is necessary to strengthen legal frameworks and institutions, provide resources, training to national authorities, and support the work of international criminal tribunals. In this regard, we are very concerned about unwarranted and unjustified coercive measures reportedly taken against ICC officials, notably the prosecutor of the court and the judges, by the authorities of the Russian Federation. Another important pillar in fighting impunity is cooperation among states. The adoption of a new MLA convention here in Ljubljana would represent a vital step in this direction. It will provide a framework for international cooperation in criminal matters and support efforts to bring perpetrators to justice. I would like to emphasize that ensuring accountability for international crimes is not a choice, but the obligation of each state. We must work together to ensure that victims of atrocities receive the justice they deserve and that the perpetrators are brought to justice. In closing, let us remember the words of Benjamin Ferenc, who devoted his life to building a more just, peaceful and humane world. Never give up hope. The hope of humankind is that compassion and compromise may replace the cruel and senseless violence of armed conflict. Thank you very much.
Many thanks, Marko, for these welcoming remarks and also reminding us of why we're doing the work of fighting impunity. In the next part of the event, we'll hear two speakers, and that will be Mr. Andriy Kostin, Prosecutor General of Ukraine, and Mr. Milanko Kajganić, Prosecutor General of Bosnia and Herzegovina, who will present challenges of fighting impunity during armed conflict and, of course, in years after the end of the armed conflict. I invite Mr. Andriy Kostin, Prosecutor General of Ukraine, to offer an address via video. Please.
Dear members of the Diplomatic Conference, Commissioner Reynders, respectful ministers, prosecutors general, and ambassadors. Thank you for the invitation to present at the opening of the EU Day Against Impunity that aims to promote national investigation and prosecution of the core international crimes. At the same time, it stands as a strong reminder to all of us of our commitments to continue the fight against impunity for these crimes. It also coincides with the Diplomatic Conference for the negotiation of the Convention on International Cooperation in the investigation and prosecution of the crime of genocide, crimes against humanity, war crimes, and other international crimes. Ukraine supports this initiative. We wish you all fruitful discussion, as well as steady progress in the matter. In 2 days, we will mark 15 months since Russia initiated unprovoked and unjustified full-scale aggression against Ukraine in flagrant violation of the UN Charter's prohibition of the use of force against territorial integrity and sovereignty of a state. As we speak, Russia continues to commit atrocities amidst the ongoing armed conflict. Undoubtedly, we are facing one of the most brutal wars since the Second World War, whereas the peaceful cities became the theaters of war. We firmly believe that grasping this momentum and ending impunity for international crimes is not only paramount for Ukraine's path towards justice, freedom and victory, but for European and global security, peace and stability. we are certain that the united, robust response against Russia's aggression and atrocities would serve as a clear warning to other actors that the world will neither tolerate nor pardon such behavior. Following the Second World War, the international community responded to the atrocities committed thereof by giving a rise to a new international criminal justice system, with the establishment of the International Military Tribunal at Nuremberg and Far East. As time passed, this system became multi-tiered, encompassing ad hoc international and hybrid tribunals, national courts and the International Criminal Court, all sharing common aim to end impunity for international crimes. Ukraine firmly believes in mobilizing international and national institutions to impose accountability on the Russian state and individual perpetrators in line with the rules of international law. Hence, from the very beginning, our primary task has been to create a web of accountability by utilizing international and national mechanisms. I'm convinced that success in our quest for accountability rests upon the shoulders of investigators, prosecutors, and security services of Ukraine. From the very beginning, our prosecutors have been active, investigating and prosecuting international crimes, often in territories with active phase of hostilities or low security guarantees. Thus, first time in history, the justice is being served in parallel to ongoing fighting in theaters of war. Of course, our work is not without the obstacles. The war, the fighting is still ongoing. Therefore, the key challenge lies with access to evidence due to hostilities or continuous military occupation by Russia. At the same time, one has to acknowledge that documenting and investigating international crimes is in itself a challenge due to specificity of offenses, as well as need for technical expertise. Therefore, it has been a learning and adapting experience for us that covers following aspects. Adopting complete legislative framework on national level, Ukrainian Criminal Code provides legal basis for investigation and prosecution of core international crimes, though we recognize that further improvements are necessary to bring the law in line with best international standards. Therefore, during the past 1 year, we are working on potential amendments with our partners. From the procedural point of view, Ukrainian legislation ensures opportunity for structural investigation, allowing us to collect information and gather evidence before the suspect has been identified. We have such investigations undergoing for the crime of aggression, crime of genocide, and war crimes. Specialized units for prosecution of the international crimes. We agree that factual and legal complexity of core international crimes differentiates them from the majority of national and transnational crimes. Therefore, success in investigation and prosecution is dependent on the existence of specialized units, dedicated staff that has knowledge, experience, and adequate resources. In Ukraine, we have the War Crimes Department at the central level that leads investigation of complex cases. It also provides procedural supervision and guidance to the regional prosecutors. With a high number of incidents, currently we have more than 84,000 registered incidents of war crimes, we realized that there was a need for specialization on regional level and established regional war crime units in war-affected areas. We immensely value and cherish assistance provided by Atrocities Crimes Advisory Group, as well as looking forward to our partnership and coordination of existing initiatives through the Dialogue Group, addressing the rights and needs of the victims and witnesses. Protection of the rights of the victims and survivors is one of the key duties of the law enforcement authorities. At the same time, participation of witnesses in proceedings is crucial for building a strong case. Victims and witnesses need to be informed of their rights and ongoing proceedings, assisted to avoid the risk of re-traumatization, etc. Therefore, in April of this year, we officially launched the Witness and Victims Coordinator Center that would allow us to ensure support services housed in the War Crimes Department and regional war crimes units. Use of Joint Investigation Team. We are extremely happy that Ukraine has been able to employ JIT as an advanced prosecution cooperation tool since 25th of March 2022. We are grateful to Eurojust for its support, as well as member states of the JIT, Lithuania, Poland, Estonia, Latvia, Slovakia and Romania for their efforts, along with the United States and ICC partnering it. The recent amendment to the JIT agreement provides for the establishment of the International Center for the Crime of Aggression, to be housed in Eurojust premises in The Hague. It is a first step towards establishing of the ad hoc special tribunal for the crime of aggression on international level. Undoubtedly, it shows the potential and high expectations we have for JIT. We equally value national proceedings, structural investigations opened by 24 states in relation to the international crimes committed in Ukraine. Cooperating with key accountability actors. The leading institution in this regard is the International Criminal Court. My office has been closely cooperating with the Office of the Prosecutor of the ICC from the moment they opened investigation into the situation in Ukraine. We have amended our legislation in order to secure ICC's operation on the ground. We commend ICC for its rapid and complementary work in Ukraine. The first two arrest warrants against incumbent President Putin and Child Rights Commissioner Lvova-Belova marks the beginning of the enforcement of justice on international level. We also cooperate with the relevant quasi-judicial accountability mechanisms, such as UN Inquiry Commission for the situation in Ukraine. Last but not least, we recognize and practice synergies with the civil society organizations involved in documenting atrocity crimes. For our part, we will continue to fight in legal battles for justice and accountability, for securing prevalence of the rule of law over the rule of force. Thank you for your attention.
Many thanks, Prosecutor General, and wish you all success with your work. Our next speaker will address challenges almost 30 years after the end of the conflict. I invite Mr. Milanko Kajganić, Prosecutor General of Bosnia and Herzegovina.
Dear European Commissioner, Your Excellencies, ladies and gentlemen, dear colleagues, it's really my honor and pleasure to attend the 8th EU Day Against Impunity for Genocide, Crimes Against Humanity and War Crimes, as the event aims to raise awareness of the nature of core international crimes and the importance of investigation and prosecution in preventing impunity. As you all know, Bosnia and Herzegovina faced a severe conflict in the period between 1992 and 1995, where about 100,000 inhabitants died and many were victims of war crimes. I believe that Bosnia and Herzegovina, as a post-conflict country, has managed, as it is rarely the case, to process a huge number of perpetrators of those war crimes, as well as to find a large number of missing persons. When we're talking about Prosecutor Office of Bosnia and Herzegovina, I have here a presentation about our work, and I will briefly pass through that presentation. Prosecutor Office of Bosnia and Herzegovina, during the course of its work until the end of 2022, the BIH prosecutor has accused a total of more than 6,800 persons. Our prosecutor office is established in 2003. The first indictments for war crimes issued in 2004 and 2005. Now we have 56 prosecutors and about 250 employees. More than 6,800 persons were indicted in total, but we have two special departments. One is for the war crime, other is for organized crime, crimes against corruption, corruption crimes and economic crime. When we're talking about war crimes, more than 1,000 persons have been charged with war crimes and serious violation of international humanitarian law. We are a small country, but we indicted so many persons. Sentences totaling is more than 3,400 years of imprisonment were rendered by final judgment for war crimes to 320 men and 6 women. At the end of the 1990s and the beginning of the new millennium, it became clear that the scope of the crimes committed in the former Yugoslavia, and especially in Bosnia and Herzegovina, was too large, and that the ICTY would only be able to process indictees with a high level of responsibility. The judicial systems in the countries created on the territory of the former Yugoslavia started preparing capacities for work on war crime cases. The Special Department for War Crimes of the BIH, as I said, began to establish its capacities during 2003 and early 2004. And on the beginning, we had 4 types of cases. First types of cases was 11 these cases with indictments filled in the ICTY and indictees who were in custody in Scheveningen and were transferred for trial to the Prosecutor's Office of BIH and, of course, the court of BIH. We had 10 dead persons, 10 indictees. Category 2 cases were cases in which the investigation was initiated by the Office of the Prosecutor of ICTY, but was not completed, and that cases were transferred to Bosnia and Herzegovina, and we finished that investigation and we indicted that persons. Third type of cases were rule of the road cases, cases that were initiated by the local judiciary in Bosnia and Herzegovina in the period between 1992 and 2004 and were sent to the ICTY for review and to obtain a standard designation for further proceeding. And the fourth type was cases initiated after 2003 and the entry into force of the new Criminal Code and Criminal Procedure Code of BIH. At the beginning of our work, we had only 4 prosecutors worked in the BIH prosecutors, and we had international prosecutors who were active from 2004 to 2011, and they help us a lot in our work, especially they bring practices from ICTY to the Bosnia and Herzegovina. English was the official language of the proceedings in that time. In the past years, the capacity were gradually built so that now there are 56 prosecutors, as I said, working in the BIH Prosecutor Office of Bosnia and Herzegovina, including the chief prosecutors. We have 2 departments, and there are currently now 22 prosecutors working in the Special Department for War Crimes. Associates investigators analyze these case coordinators, professionals, and administrative staff work with prosecutors in Special Department for War Crimes. Hence, the department employs slightly more than 100 employees, or about 40 or 50% of the total human resources in the prosecutor office in BIH. Here you can see a map of teams in BIH. We have 6 teams in Bosnia and Herzegovina. Map shows each team's cover area with about 20 to 30 municipalities in Bosnia and Herzegovina. The Special War Department for War Crimes deal with criminal offenses of serious violation of international humanitarian law, including genocide, crimes against humanity, war crimes against civilians, war crimes against prisoners of war, and war crimes against the wounded and sick. Regional divisions has shown greater efficiency in case work because prosecutors and supporting staff are able to better understand the scale of crimes on specifics of certain areas where conflicts took place, which specific armed formations participate in them, as well as who were the top commanders on some specific area. In 2022, the Special Department for War Crimes issued indictments in 20 cases against 62 accused persons. So you can see we have a lot of cases, no matter it's 30 years, actually 31 years after war started in Bosnia and Herzegovina, and we are focused now our work on the complex cases with a large number of suspects. Cases with the highest level of responsibility and with a large number of victims. In some of the cases, dozens of victims are included. Activities implemented within the framework of the revised National War Crimes Strategy in order to significantly reduce the number of active cases. Prosecutorial decisions were made. Cases were transferred to the prosecutor's office of both BIH entities, Federation of Bosnia and Herzegovina and Republic of Srpska, and the Brčko district of Bosnia and Herzegovina. As part of regional cooperation in the fight against impunity for war crimes, we transferred the 9 cases in the regional countries. 6 of that cases we transferred to Serbia and 3 in Croatia. This is the highest number of cases transferred per year in the last 10 years. Several activities were undertaken in cooperation with the prosecutor's office of the region, as well as with the chief prosecutor of RMST, Serge Bramers, in order to define activities that will focus on the suspects and indicted persons hiding in other countries in order to prevent them from avoiding justice. Here you can see indictments in the years in 2019 to the 2023. As I said, in 2022, the focus of the work was on complex war crime cases. Archive quota of the Special Department for War Crimes Department was more than 116%. And at the end of the 2021, Chief Prosecutor issued an obligatory instruction regarding the publication of confirmed indictments, state of facts in anonymized form on the official website of the BIH Prosecutor Office, which is a positive step in transparency of the institution. This is very important decision because we have at least 3 sites in Bosnia and Herzegovina, and it is important for us to show everybody in Bosnia and Herzegovina what we are doing and who we are indicted and with who evidence we're dealing in our cases. When we're talking about witness support and investigation department, at the beginning, some 70 years ago, the witness support and investigation department had 5 to 6 investigators. Today, it has reached the number of about 30 employees. This professional staff annually examines about more than 1,000 witnesses, approximately 50% of persons out the field and the other 50% in the premises of the prosecutor's office. We participate in a large number of examinations and identification processes in all parts of Bosnia and Herzegovina. Last year, they conducted around 50 reviews of archives and archive material as part of the evidentiary material for war crimes cases. They also performed other activities in accordance with their authority and the instruction of the assigned prosecutors. Investigators have the status of an authorized official person. The primary goal of support officers for vulnerable and sensitive witnesses is to ensure appropriate psychological support and assistance to witnesses during the investigation phase, aiming to avoid the possibility of additional negative consequences, new suffering or trauma to potential witnesses when testifying. When we're talking about witnesses and evidence, according to the records of the Court of BiH and Herzegovina from 2005 to up to 2022, more than 13,000 witnesses were supported by the Witness Support Department and testified in courtrooms about war crimes. A large number of witnesses examined in investigations should certainly be taken into account as well. About 17% of witnesses, or every 6 witnesses on average, testified with one or more protective measures. The witnesses reside in BiH, but also in the countries of the region and overseas, which makes testifying difficult. When we're talking about missing persons, the total number of missing persons after the war in BiH was more than 33,000. Today, around 7,600 persons are still being searched for, which means that we find and identified more than 76% of the missing persons after war. Missing persons are found mostly in inaccessible locations, natural pits, river gorges, remote forest locations, sometimes also in areas that were mined during the war. And investigators of the Special Department for War Crimes annually conduct more than 100 examinations and searches for the missing in all parts of Bosnia and Herzegovina under the supervision of assigned prosecutors. Cooperation with the RMST and partner institution, during the 2021, the Chief Prosecutor passed a decision on the formation of teams within the Special Department for War Crimes, all in order to group the remaining cases by areas to ensure easier work and gathering of both subjective and material evidence. The International Criminal Tribunal for the former Yugoslavia, now the International Residual Mechanism for Criminal Tribunals, has provided access to EDS database for the Prosecutor's Office of Bosnia and Herzegovina. Therefore, all prosecutors and professional staff can search the said database themselves for easier evidence gathering. Since March 2023, one of the prosecutors of the RMST is at the Prosecutor Office as advisor and providing us professional assistance and advice to war crimes prosecutors. When we're talking about searching suspects, in the past almost 20 years, the BiH Prosecutor Office, together with partner institution, has located a large number of suspects who were abroad. Activities were carried out to extradite them to Bosnia and Herzegovina, and some 20 to 30 suspects have been extradited to date. The largest number of suspects were extradited from the USA, followed by Netherlands, France, Germany, Spain, Sweden, other countries, European countries. And a few days ago, a person reported for committed war crime in Kajganić, that is the town in Bosnia and Herzegovina, was deprived of liberty near Boston in the USA, and we hope he will be extradited in Bosnia and Herzegovina. By the end of 2021, the Court of Bosnia and Herzegovina issued active arrest warrants for war crimes for about 130 persons, including 63 persons for whom the indictment was confirmed. When we're talking about the difficulties faced by the Prosecutor Office of Bosnia and Herzegovina, a large number of unavailable reported and suspect persons in 123,000 cases, 23 cases, there are 361 unavailable persons. most of whom are located in the countries in the region, in Serbia and Croatia, and some of them in Montenegro, and they can't be extradited in Bosnia and Herzegovina because they have dual citizenships. The growing uncooperativeness of witnesses due to frustration with the long passage of time since the commission of criminal offenses, then death of witnesses and reported suspect persons because many of them are older persons, difficulty obtaining evidence in cases, a lengthy court proceeding during the course of which witnesses or the indictees often die, and small percentage of cases and with the plea agreements. Since the beginning of the work of the Special Department for War Crimes to this day, less than 40 defendants, or about 3%, have pleaded guilty by concluding agreements with the Prosecutor Office of Bosnia and Herzegovina. Significant changes in the recorded progress, better cooperation with the countries of the region in terms of proceeding requests and taking over cases, especially with the Republic of Serbia. We signed a lot of agreements with the regional countries to be sure that we will fight together against impunity, and there are some memorandums and agreements with Serbia, with Croatia, and with Montenegro. Methods of improving cooperation between institutions from other countries in the region. We need to be faster when we execution requests for assistance. We need better communication between institutions in order to prevent parallel investigation and exchange of experience and jurisprudence in the prosecution of criminal cases through aspect and educational visits. In its work, the BIH prosecutor cooperates with many institutions of civil society and civil associations all around Bosnia and Herzegovina. We have a cooperation with the Association of Victims in War Crimes cases is particularly frequent, and periodic meetings are held with the victims' representatives in order to hear from them about their expectation from the judiciary, especially from the Prosecutor Office of Bosnia and Herzegovina. That was a shortly presentation. I just want to highlight that we are not a member of Eurojust, and that is one of our biggest obstacles in our work, and we hope we will sign the agreement with Eurojust, and we will be faster in especially our MLA agreements and MLA requests with especially with the regional countries. Thank you very much once again.
Many thanks, Prosecutor General, reminding us all that ensuring accountability is not a task, but a long-term commitment where you need ideas for 30 or even 40 or even 50 years after the end of the conflict. And that will be also the theme, the discussion of our panel. We have 6 distinguished panelists and the moderator, and I will invite Ms. Anna-Karin Svensson, the moderator, and all the panelists to join the podium for the panel discussion.
So, dear Excellencies, colleagues, ladies and gentlemen, I'm very happy to be with you here in lovely Ljubljana to mark the EU Day Against Impunity. And as others have said, it's a great idea to have this in the margins of the MLA conference. So thanks to the organizers for making this possible. With me on this panel, I have some very distinguished and experienced guests, and I'm very happy to welcome first here to my left, Commissioner Reynders, Didier Reynders, and he's been a Commissioner for Justice since 2019. And before that, he had several top ministerial posts in his native Belgium. And further along the line, we have President for Eurojust, Ladislav Hamran. He's been President for Eurojust since 2017. And before that, a prosecutor back in Slovakia. And to the very left, Mr. Peter Frank, who is Federal Public Prosecutor General for Germany. He's been there for several years, but he has also served as a judge and in the Bavaria Ministry of Justice in several posts during the years. And to my right, I have a fellow Swede, Ms. Hanna Lemoyne, who is Deputy Chief Prosecutor at the Swedish Prosecution Authority, working at the Serious Crime Unit and specializing in war crimes. And you've been in several posts. You have a broad experience in prosecution and been working for IIIM also. Then we have Ms. Beth von Schack, who is Ambassador at Large at the US State Department. And you were appointed last year to this post. Before that, you were, among other things, a professor at Stanford University. So also a lot of experience here. And last but not least, Ms. Anja Neustadt, who is legal director for the Docket Initiative at the Clooney Foundation for Justice. And you also have a lot of experience working in different civil society organizations, Amnesty International, Human Rights Watch, and in academia. So you see, I have a lot of experience, and I think that while my panelists will have a lot to say today, but I hope that we will have some time at the end also for questions from the audience. There will be a microphone so that you on the floor here in Ljubljana will be able to pose questions. But I also encourage you who are listening in online around the world to send in questions on email. You find the email on the invitation. So please start preparing. But without further ado, I will turn to Commissioner Reynders to ask you some questions. We have heard from two prosecutors here today presenting challenges to fight impunity during armed conflict and decades after the end of the conflict. And both these countries were recently granted EU candidate status. And today we actually celebrate the EU Day Against Impunity, so I think it's very relevant to ask, what does this mean? And more concretely, what is the role of the EU in seeking justice for international crimes? Please, Commissioner.
No, but first of all, I want to say that the European Union is founded on some values, and you know that the values are enshrined in the Article 2 of the treaty when we are speaking about rule of law, democracy, fundamental rights. But the main goals of the Union is also enshrined in the treaty. And if you look to the Article 3 of the treaty, you will find the first goal to promote peace, and the second one to organize a union of freedom, security, and justice for the citizens. And if you want to do that, of course, you need to fight against impunity, and you need to organize the prosecution of all the perpetrators of different crimes, but certainly perpetrators of international crimes. And so on such a day, with the celebration of our work against impunity, it's important to say that what we try to do is to provide all the necessary tools to the prosecutors and to the judges to do their job, to be very concrete. I'm Commissioner for Justice. It's not my responsibility to say who is guilty or not. I have my idea about the different responsibilities. But my responsibility and the responsibility of the Commission at EU level is to provide all the necessary tools. I've explained, I don't want to repeat, that to do that we have tried to build on the existing institutions that we have, to work with the Prosecutor General Office in Ukraine, to work with the member states, having their own investigations, to work, first of all, with Eurojust, because it was very important to amend the regulation on Eurojust to be sure that it's possible to have a secure storage of evidence of international crimes. And we are building on existing tools because we have seen with the Prosecutor General of Bosnia and Herzegovina that it's not only a work for one day, 1 week, 1 month or 1 year, it's for decades. If we want to be sure that it will be possible to bring perpetrators of international crime to justice, we need to know that we'll have to work during a long period of time. And to build on existing and very robust institutions is the best way. The reason why we are doing that with Eurojust, and now with, you have listened from the joint investigation team, but also with the ICC. And if we need to come with some new institutions to find a way to organize also accountability for the crime of aggression, we did the same. We are working on the basis of Eurojust, on the joint investigation team, to collect evidence of the crime of aggression, to exchange with prosecutors. And now we are thinking about the best way to have a dedicated tribunal to organize a trial of the crime of aggression. So it's very important. But saying that, we are not alone. We have different partners out of the EU, and hopefully. And what is the most difficult task for the moment is to have a good coordination of all the initiatives. And thanks to different initiatives like the dialogue group, to be just with one example, but also within the ECHA, the cooperation that we have with the US and UK, we try to organize a coordination. And I must say, now it's maybe the most difficult task. There are so many initiatives to try to take part in the process that we need to build maybe on a good coordination, and we try to do that also.
Thank you. And I want to turn to you now, Ladislav. Can you say something more concretely on how Eurojust can support member states in order to fight impunity?
Thank you so much, Anna-Karin. As it was highlighted many times, the key today is coordination and cooperation between different jurisdictions. Actually, a few days after the Ukrainian armed conflict started, we were confronted with emerging and rapidly changing operational landscape. So we saw actually that the law enforcement community and judicial community in different countries has initiated different national investigations based on the principle of universal jurisdiction. Today, as it was mentioned, we are aware of more than 20 national investigations which are looking into the current armed conflict in Ukraine. So now we also, when we inquired who is investigating what and who has doing what, we simply realized that those national investigations are different. Some are really structural investigation looking at the armed conflict as such. But we have also so-called national investigations which are looking only at their own nationals, either as perpetrators or victims of war crimes. And we had then also countries which do not collect admissible evidence. They are more or less observing and collecting information to decide at later stage whether they will open their own national judicial investigations. So we simply realized that we have to coordinate and we have to understand who is doing what. This was the key principle or key reasons why Eurojust invited many jurisdictions, actually 36 jurisdictions, and we were discussing and exchanging about the scope of the investigation, nature of the investigation, and actually understanding in early days what is happening in different countries. Countries were determined to collect evidence. And obviously, the key is that we collect admissible evidence which can be easily shared across jurisdictions. This principle prompted the creation of the joint investigation team, which today has 7 countries as members, and Eurojust and ICC are participants, so they have supporting role to make sure that the countries have all the support which they need and require for their national investigations. We realize that this is still not enough, and another key word in these accountability efforts is centralization. We could see that countries are actually collecting evidence, but we do not see this evidence at the central level. Countries are more or less doing this in, or were doing this in isolation, and investigating core international crimes, especially genocide or crimes against humanity, is simply essential that you look at the evidentiary situation as such. What might be seen at the national level as isolated act, if you put all these isolated acts together, you may actually conclude that we already have enough elements to conclude that crimes against humanity were committed because it's proven enough that these were systemic and widespread attacks against civilian population. And later on, I would, if there is a time, I will explain what are the underlying reasons for doing something also for the crime of aggression in the form of the International Center for the Prosecution of the Crime of Aggression. Thank you.
I think we have time, so why don't you continue on that a little bit?
Okay, thank you so much. I was just aware that my time is limited to 3 minutes, so I wanted to make sure that you are happy with me also at the end of this presentation. The same principle as for core international crimes go for the aggression. We have now 5 countries which initiated their own investigation into the crime of aggression. And let's be very honest, we do not have the necessary expertise for investigating the crime of aggression. We even have different definitions for the crime of aggression at the national level. We, of course, see a need to start collecting evidence now. We as prosecutors, we don't want to wait several years until political negotiations concerning the crime of aggression will bring a kind of end result. But then having an end result at the political level requires that this end result will be implemented, that we have a seat agreement with a country which will host a court, a tribunal mechanism. That people are recruited, that there are rules of procedure, and there we can then start building up the case. We believe that it's time to act now. We have actually an excellent opportunity that countries are collecting evidence which are useful or can be used for proving the elements of crime of aggression. So this is the underlying reason behind the ICPA or ICPA, that we as humanity act now, today. We actually centralize already available evidence in different jurisdictions, and we as international community collectively evaluate, analyze already collected evidence in order to check whether crime of aggression has been committed, and if yes, who are the perpetrators of that crime.
Thank you very much. And now I think it's time to dive even deeper into the soil and look at what is being done at national level. And I turn to you, Peter. In the last few years, Germany has been one of the leading member states in the fight against impunity. You have tackled many prominent cases. Can you tell us a little bit about some of the measures implemented that can explain this success?
First of all, many thanks for that you think you have got success in Germany. But I think in German we said success has got more than one father and more than one mother. And I think there are several reasons why we have got such a success. I would say first, it's the legal framework that we have got in Germany. When the Statute of Rome was implemented in German criminal law, it was 2002, and there was a present by the German legislator the principle of universal jurisdiction. So for me, we can start every investigation for every conflict in the world. So we must, it's not necessary that you have got a German perpetrator or perhaps a German victim. We can look on every country of the world, and if there is a conflict or is there a civil war or something else, we can start. It's not an application, but we can start an investigation. And also there was another part of the legal framework that you can be a perpetrator of a war crime or genocide or crime against humanity as well as a member of a terrorist organization. So this was a very important step for us when a lot of Germans went to Syria in 2011 or 2012 as foreign terrorist fighters, as well as female supporters and members of Daesh, because we started first the investigation files as membership of counterterrorism, of membership of terrorist organizations, but when we looked in the file and we looked what they have done there in Syria, often we saw that they were involved in slavery of Yazidis. Then they were involved in, especially in war crimes against property or war crimes against persons. And so we can convict them as member of terrorist organization as well as perpetrators of war crimes or perpetrators of crimes against humanity. This is one of the reasons, the legal framework. The second reason, I think, is specialization. Yes, we have got in a decision by the Parliament, by the German Parliament, 2002, that we have got a specialized unit for war crime and genocide and crimes against humanity in my office, only in my office, and it is in the Federal Prosecutor General's office. So it is the highest prosecution office in Germany. There is a specialized war crime unit. We started in that war crime unit 2002 with one prosecutor. 2009 there were 3 prosecutors. Now we have got not only one unit, we have got 3 units. We have got 70 prosecutors who are dealing only with war crimes, crimes against humanity and genocide. And as well in the counterterrorism department, because you can be a member of a terrorist organization. So more than 20 prosecutors in my office are dealing with such crime. And also the police unit, we have got a special war crime unit at the BKA, the Federal Criminal Prosecution Office in Germany, who is our investigation team for the prosecutors. The third reason, I think, is political support and political will. We get the support by our government and also by the parliament. I've told you that we have got now 70 prosecutors only in the specialized unit, and these need the political will to support us with a higher budget. And I would say the last important reason is to cooperate in an international network. You can't be, you have only success as you work together with other partners. Partners are organized in a genocide network, Eurojust, but also partners, other prosecution service in other members of the European country have got a similar legal framework than Germany, and they have got a similar, I would say, goodwill to investigate in that field. I think these are the 4 most important reasons that we have got, why we have got success in Germany. Thanks.
Thank you. So specialization, political support and the cooperation, that's the recipes for success. And could you just very, very quickly, you mentioned some cases, but what would you say would be your main successful case in Germany?
The main, a lot of them are very important. But I would say they have got, I would say, 2 or 3 very, very important cases. It was the Koblenz conviction against members of the Syrian intelligence forces or intelligence services, and so the Koblenz conviction said that what Assad and the Assad regime made in also makes perhaps in Syria, but made in Syria since 2011 was a crime against humanity. It was a systematic and a massive attack against their own civilian population in Syria. So not only these 2 men, it was a colonel and I think a sergeant of an intelligence service, were, I would say, accused in that trial. I would say the Assad regime was accused at that trial, and it was a conviction by the court that says that the Assad regime made these crime against humanity, these attack against the civilian population. The second, I would say, was the second case was a Daesh case that what Daesh made against the Yazidis was a genocide, a very massive attack against the population to destroy the Yazidi community. And I would say the last one, it's very interesting for us lawyers because it was a case not so popular. It was a case against an Afghanian, an officer from the Afghanistan armed force. But he made a torture and he killed somebody from the Taliban's. And there was an enactment from our Federal High Court of Justice that there is no immunity, ratione materiae, for the officials of a country. In an armed conflict, there is no immunity, ratione materiae, for an official of a country. And that is a very important case because that was difficult in the international community, especially the International Law Commission. Members of the International Law Commission said that there is immunity, but our Federal High Court of Justice said there is no immunity in war crimes, genocide, and crimes against humanity.
Thank you very much. And now I turn to Hanna, and Sweden has also been very active when it comes to prosecuting in the fight against impunity. Do you share the views of Peter on what it takes to be successful in prosecuting for these crimes?
Yes, absolutely. Peter stole all my good points. But I mean, that's, yes. And maybe just to add it a little bit from my view and maybe give some examples. And also again, which I don't think you did mention universal jurisdiction as well. Having a legislation in place, both material and procedural, is of course key for successful investigations and the possibility to prosecute, but also having dedicated and committed prosecutors and investigators, and you get that through having specialized units. The reason why we need these in these cases, I say, is at least threefold or 3 reasons for it. One, which has been touched upon before, this area of law is difficult. Not only do you need to apply your national legislation, you need to be aware of the international jurisprudence, legislation, and customary international law. This makes it a very complex area of law, which you need to be familiar with. Secondly, we have the evidence. In conflicts, the evidence are shattered all around the world, and you need to look for it not only within your own jurisdiction. For myself, I have traveled to many countries to interview witnesses. I've taken a Swedish court to Shangogo in Rwanda to show them the crime scene. I have had video conferences with many, many countries. So this means that these investigations take time and you need to stay focused. And thirdly, we have the cultural challenges that we face in these investigations. Again, to give one example, we needed to, in several of our cases, show the context where a crime were committed. I'm thinking in particular regarding in the Islamic context, how exactly humiliating it is to put a foot on someone's head. I do think we all understand that, but you also need to see it from the specific context in that culture. And understanding that led us to conviction for war crimes against persons through the outrage of a person's dignity. So this, I would say, are challenges that we need to face, and we need to face them through specialized units. In Sweden, we also have these specialized units. We've had specialized units within the police and the prosecution authority for approximately 15 years. And as you heard from our minister, there's also a political support for this, and from our leadership, which is important. As I said, these investigations take a long time. And having these specialized units means that we can offer our prosecutors training. For example, we've had peers from the international tribunals, from ICC, coming to us, training us, sharing their experience with us. Nowadays, Swedish prosecutors also train and exchange experience with other units prosecutors in other national authorities. Because what has also been said, this cannot be done alone. It's not possible for one national authority, for one international tribunal, for the ICC to alone fight impunity. This is something we have to do together. Yet another example of this is our cooperation with Germany, where we've had situations where, for example, German investigators, prosecutors have turned to Sweden in specific investigations and asked whether we could have a relevant victim or witness to their investigation. And in one specific case, turned out we've interviewed a person a couple of years back that was extremely relevant to that investigation in Germany. And when we interviewed this person in our more structural work, of course, we didn't know that a couple of years later on there would be an identified suspect and a criminal investigation. So again, this shows the need for dedicated work on the long term with specialized units, and that we do this together.
Thank you. You are also a contact point in Sweden for the Genocide Network. Can you tell us a little bit about the role of the network and what value it brings to your operational work?
Absolutely. The Genocide Network is a EU forum for practitioners, prosecutors, where we exchange experience, information, best practice, basically. And I cannot overestimate the value of the network. I would say it's an enormous force to what we do twice a year, meet up in person and exchange these experiences. We have different presentations, but we also have closed sessions where we go more into specifics into our different works. And to be able to exchange those experiences with peers is extremely valuable. I can give you one example. For example, when it came to the conflict in Syria, we were flushed with digital evidence on crimes committed in Syria. We tried to, of course, to investigate to see what had happened, for example, after and before a photo was taken, a very disturbing photo. It could be a photo of a person, a soldier, for example, posing next to a dead enemy in a very humiliating way. And if we couldn't investigate what had happened before, at least we wanted to do something with this photo. And then turning to our colleagues, we learned that both Finland and Germany were investigating this, as I mentioned, as an outrage, as a war crime through the outrage against dignity. And that helped us to form our investigation and our indictment. And today we've had several of these cases in Swedish courts, including one that went all the way up to the Supreme Court, which also clarified that this indeed is a war crime.
Thank you, very interesting. At this point, I think we should raise our eyes a little bit and scan the horizon for the global view. And who better than to guide us than Beth? Could you tell us, because US is an important partner for the EU, and you've been working with Eurojust and the Genocide Network. So from your perspective, how do the EU's accountability initiatives connect globally with endeavors in other regions?
Yeah, thank you so much. Let me start by saying it's a real honor to be able to participate in the EU Day Against Impunity, and congratulations to all of the delegations here for all of your hard work to date, and we wish you all the best as you finalize this project. I have to say, from the United States perspective, we really admire what's being done in Europe. It's been incredible to see what individual prosecutors have been able to do, but as part of, as you've all described, really a community of practice of war crimes, crimes against humanity investigators and prosecutors who have the luxury of having the Eurojust network, the EU Genocide network, to bring them together, to share strategies, as you described, to share theories of the case, to share evidence, to share case files. It's really remarkable what's been able to be produced, and I think it's a model that might be able to be replicated elsewhere around the world. I was in Buenos Aires relatively recently and was describing what the Europeans have been able to do, and they were quite intrigued, and we had a sort of brainstorm session about whether something similar might be able to be created for the Western Hemisphere. Our war crimes prosecutors have not been able to pursue as many cases as have been done in Europe, but we're making some progress in that regard. So I can actually announce today that there was a judgment in our second case under our torture statute, 18 U.S.C. 2340, alleging actually a United States citizen having committed torture in Iraq. This is the second case, the first being the Chucky Taylor case that was several years ago. And I think in many respects, our prosecutors have been very much inspired by seeing what is happening in Europe. Not only are you developing the law, but you're also, I think, building confidence in war crimes prosecutors and investigators around the world. We're also seeing, I think, some incredible innovations beyond Europe and the United States. So as the Ambassador at Large for Global Criminal Justice, I take my title very seriously. I do travel the world. I've been in the Gambia recently and in Ethiopia and in Liberia. All three of those states are embarking upon justice processes, with the Gambia exploring the potential for a regional tribunal with ECOWAS, which is the regional or the sub-regional political organization. A potential partnership there to create a new model of a hybrid tribunal, again prosecuting crimes of the past under the Jammeh regime. Meanwhile, in the United States, we have one of Jammeh's junglers in custody who will be being prosecuted under our torture statute in Denver. And so this, perpetrators do not stay put. These are international crimes. And so ultimately we need an international system. And as my former boss and predecessor often says, it's an ecosystem. And each of the nodes within that ecosystem needs to be nurtured in order for the entire system to work. We cannot rely upon international tribunals, although they play a very important role, to do all of this work. Really, the lion's share of the work is going to be done by national systems. And that's why what Europe is creating in terms of this network and what is then inspiring efforts elsewhere is so important. And so in Argentina, I had conversations not only about their own cases against their own civilians and citizens, former military members from their dictatorship system, but also some of the investigations they've opened for Myanmar, for example, or Nicaragua, or for the genocide against the Uyghurs in China. And so them starting to think about structural investigations, et cetera, in their own system, even though it may be unlikely that defendants from those crime scenes would necessarily travel to Argentina, as lovely as it is. Nonetheless, being able to open an investigation, potentially issue an arrest warrant, which then could be plugged into the Interpol network, which then would go out to systems around the world, it closes the space for freedom, and it removes the privilege of anonymity, I think, that some of these perpetrators think they will enjoy. And much of that is about taking down the privilege of impunity, and eventually noting that the international community is watching, that prosecutors and investigators are standing ready, that we have the legal framework in which to move against individuals, and we have collected the necessary evidence or can get in touch quickly with individuals who have collected that information in order to be able to move forward, to take advantage of those targets of opportunity when they come within the jurisdictional reach of a national prosecutor somewhere, anywhere in the world.
Thank you very much. So to have a global accountability framework, we really need an interplay with the domestic and international efforts. That would be your sort of vision. Thank you. Then I will turn to Anja from the Docket Initiative, and you will give a non-state perspective and a global view. And can you tell us a little bit more about what role can civil society organizations play in the global accountability system for core international crimes?
Thank you very much. And it's a real honor to be here. Thank you very much for the invitation. I will be brief, because I know we need to leave time for questions. So I just wanted to say that I'm sure a lot has been said here about the uniqueness of this historical moment, where the aggression against Ukraine fell on the foundations of the international system that by now can be tested. And we see it with countries that have never before had universal jurisdiction cases, opening them, with ICC opening the investigation within weeks of this phase of aggression, and so on. But I think it's also a unique moment for cooperation between civil society and law enforcement agencies elsewhere. And that's also as a result of really long and hard work, including by some of the NGO colleagues who are present here, but also increasing recognition by the law enforcement agencies, by the prosecutors, by the police, of the role that civil society organizations can play. I think it really probably would not have happened 10 years ago, the way it is happening now, because with this time there is increasing trust from the prosecutors, from the police, into what the NGOs and other civil society actors can bring. And frankly, a lot of lessons learned by the civil society. We also have all come a long way, understanding that an incredible 200-page report put on the prosecutor's desk with a caveat that that's it and we will not give you anything else does not really solve the problem. That it's a very different way of working that we as civil society actors need to employ that will ensure that what we bring to the process is useful, and also that we know our place in this process going forward. In terms of what civil society actors can bring, of course, it's very often access, often first responder type of access before the prosecutors. Ukraine would not be a very good example because obviously everybody's there from day one. But I can tell you that when I worked, in Chechnya, in Syria, and in many other places around the world, that was not the case. Not only NGOs, but journalists in particular often were the first on the crime scene. And now there is a lot of discussion about how we can make sure that the journalists also who are first on the crime scene can be useful for eventual criminal prosecutions. It's also access to witnesses. I spoke to quite a few prosecutors and police in Europe over the last year about access to Ukrainian victims, where they were maybe slightly disappointed that this broad outreach effort with posters in airports and train stations has not really produced the numbers of witnesses that they were hoping for. And ultimately it was, often NGOs that directed witnesses to them and also assured them that this is a worth thing doing. Then it's also, I would say, just the time and effort that NGOs, civil society actors can put in the process when it comes, for example, for open source intelligence, which obviously is happening now within many police and prosecutorial units, but for which we, and especially more specialized organizations, have all the time in the world, or that's kind of their core mission. And even though there is a clear understanding that what they produce may not go directly into the investigative file, they might have saved hundreds of hours of work that would have taken an investigator to get from A to B. And finally, which is I think very important and which I know that a number of NGOs present here are pushing to be included fully in the draft convention, is this really support, full support to victims and protection. I'm sure a lot has been said about that. I'm not going, there is, you know, a letter from civil society to the discussions that are happening here that highlights it very clearly, but it is often the role that NGOs and other civil society actors play by supporting the survivors, the witnesses, legally, and in many, many other ways. I just wanted to make one point that I think is very important for this to actually work going forward. It is the, I would say, agreed upon processes for this cooperation. Just like the countries here are trying to agree on methods of cooperation, it is equally important to have some jointly recognized agreements of ways of working. And they cannot be imposed fully by the official bodies, but they also cannot be assumed by the NGOs. It needs to, or civil society actors more broadly, it needs to be a true agreement, because only then it will be efficient.
Thank you very much. And you have a new report out that you all should read to know more.
Yes, so I thank you very much, and that will be literally 2 minutes. But I did want to bring your attention to one of the initiatives that it's not even a report, it's basically an online tool. Very briefly, it started with a very practical question. We don't do academic reports, we're not academia. We started working on Ukraine in February. Last year, and one of the questions was immediately, because we focus a lot on universal jurisdiction cases while also working with Ukrainian prosecutors and ICC, is where can we take these cases beyond Germany, Sweden, the Netherlands, and other countries that everybody knows about. The question was, what if Russian perpetrators show up in Turkey, as they did, by the way? What if they show up in countries in Eastern Europe that have not had these proceedings before, but have very good laws, it seems? What if they end up in Argentina, Venezuela, Thailand? And we looked everywhere, and we realized that there is no summary out there. So we decided to do it ourselves. So I encourage you, there are some printouts which summarize the findings of this survey, but ultimately it's justicebeyondborders.com. It's an online tool where anybody, it's mainly useful for practitioners, obviously, where anybody can log in and have a world view, a regional view, and a country view on which crimes are criminalized, what laws exist procedurally, and you can do all sorts of different searches depending on your starting point. If you have a survivor in a particular country, what can be done? If you have a perpetrator in a particular country, what can be done? And some of the findings are very interesting and probably food for thought, and some of the problems that this conference also is trying to solve, which is, we basically found that 153 out of UN member states have laws that criminalizing at least one of the 4 international crimes. And more importantly, 148 states have laws that allow to prosecute one of the serious international crimes committed beyond their borders. However, so far only 12% of the countries have done so. And we really hope that these numbers will change in the near future. Thank you.
So much remains to be done. Now we have listened to many insights from the panelists, but there is still time to pick their brains a little bit more. So I turn to you in the audience. Is there anyone who wants to pose a question? There should be a mic going around, and I would kindly ask you to be very crisp in your questions, so that we can have several of them. And please state your name and country.
May I first pose a question which we got from the online audience? And that is from Mazen Darwish from Syrian Center for Media and Freedom of Expression. And the question is to both prosecutors present here, to Peter and Hannah. Can you tell us about the role of local civil society in support of your work and investigations? So how does a local civil society fit in in your work and ensuring accountability.
Thank you. Thank you, and thank you, Marcin, for the question. Certainly, I've seen how local civil society has played a crucial role in identifying cases, bringing it up through the ladder, and then eventually coming to the Swedish prosecution authorities table to look at that evidence. I think that is exactly what is needed, especially when we're investigating crimes committed at a place where we don't have access and where there's still a conflict. Of course, we cannot ask civil society actors to work on our behalf, but having social society actors bringing to our attention situation is, of course, extremely helpful. So yes, I would say that is extremely helpful, and nonetheless not uncomplicated for a national jurisdiction. We cannot have private initiatives working for us, but I can definitely see how that is sort of initiating our work and how we can take that further.
I understand the word local initiatives or local networks, as it especially the question comes from the Syrian network and the Syrian Center, that local means Syrian organizations, and I would explain the importance of such local networks at a case from us. We had a German woman. She traveled to Syria, I would say 2015 or 2016. He joined there the Daesh, the Islamic State. She married foreign terrorist fighters. She founded a family there, and sometimes she came back to Germany. She was there because it was necessary to get some medical support to her. But she wanted to travel. She wanted to travel back to Syria, and we investigated in this case, and we observed her in Germany because we knew that she wanted to go back to Syria and joined again the Daesh. And we observed her in Germany, and she traveled from the northern part of Germany to the southern part of Germany, and she wanted to cross the border to Austria, and then this region, the Balkan and Turkey, and then to Syria. And we had got we observed her as well with I would say with technical equipment in their car. We heard everything what she had told in the car. And she told to the other passenger of the car that she had the family in Syria, and she had a slave, a female Yazidi slave with a young child, and sometimes it was a very hot period in Syria and in Iraq, and this child of the slave was crying, and her husband thought that this is not good that the girl is crying. And her husband decided to bring this child into the sun in the yard of their home, of their farm, I would say. And this young girl died in the sun, in the middle of Iraq or Syria. So we know that, but we did not know who was the child, who was the mother of the child. And this local Syrian organization organized it. We started first the trial. We did not know who was the girl. We did not know died the girl, or at that time we know that the girl was brought to a hospital. But we thought she died. But we didn't know who was the girl and who was the mother of the girl, the slave, the Yazidi slave. And the local Syrian organization, one of the charity organizations in Germany, organized as the mother. They were always connected with other refugees from Jesuit community in Europe, and they brought us the mother. And the mother was then as victim at the trial, and she told what happened. at a trial. And so it's very important to have such organizations, because they are so close connected to the people in the conflict zone, where it's not possible for us, for mutual legal assistance, to do that with Syrian or sometimes with Iraq. And so it's necessary to have this good, close connection to these organizations. Then they can bring us some information. They can bring us always some testimonies and such victims. And so it's very important to work with these organizations. Thanks.
Thank you. I don't see any hands in the audience. Yes, there we have. From Bosnia and Herzegovina, I think.
Hi. My name is Jasmina Pjanic. I'm head of the delegation of Bosnia and Herzegovina. I first want to regard the members of the esteemed panel. I am so thrilled, and it's so applaudable that you put so much effort and energy in fight against impunity. And I'm so glad, that you decided to address the delegates of this conference. You give us a boost, to continue and to adopt the convention, hopefully on Friday. So thank you for that. On the other hand, I don't have a question. I'm sure, that we are all about to, leave the session, and thank you again for all this. But I want to share one thought with you. After esteemed member of the panel from United States, professor, mentioned, we are one ecosystem, and it's very important for all of us to collaborate on everything, but the fact is that majority waste of the cases will fall onto national level, and that's a fact. And as we just heard from the head prosecutor of Bosnia and Herzegovina, there was a vast majority of cases dealt, for example, in our country. Let us not forget the importance of the legal challenges, international legal challenges dealt at the national level. We have dealt with issues of command responsibility, joint criminal enterprise, extremely complicated issues of armed conflict, international armed conflict and internal armed conflict within one country. Serious issues which take serious consideration. I just want to remind esteemed members of the panel, and delegates, how important it is to take the lessons learned from the national jurisdictions and to learn the lessons and use them at the international level. Please don't ignore that, because there was a lot of money invested in the national jurisdictions in order to reach this end. So that was all that I needed to share with you. Thank you very much for your attention.
Thank you very much. And I think, yes, that's been stressed by several members of this panel, also the interplay between national and international work, and also the need to coordinate and work together. I don't know if any one of you want to, Beth, do you want to comment?
Just one remark. I think you're absolutely right. It really will be the most important level is the national level, and maybe some cases would go up to an international level or a regional level. The US, the UK, and the EU have created the Atrocity Crimes Advisory Group precisely for this purpose in the Ukraine context, to invest in what the Prosecutor General is trying to do with his 84,000 plus registered potential war crimes and other atrocities, to provide him with the support he needs from the international community, from experts, many of whom have served in international tribunals or with national war crimes units, including the ICTY. And so you have someone who may have experience prosecuting the siege of Sarajevo, who then now is working side by side with prosecutors who are prosecuting the siege of Mariupol. And so now what this effort is trying to do with Didier's help and others is to start it immediately so that he can be doing this work now, even as the conflict is ongoing, so that evidence can be preserved, dossiers can be created, cases can be brought, and then only those cases that can't be brought in the national system for whatever reason would then potentially be brought in another maybe international or internationalized system. And so I think that's so much of what this gathering is about, is expressing the importance of what national systems are doing, and that we all have to support each other through genocide networks, through capacity building, through funding, through civil society, all of that.
Thank you. Yes.
Just maybe one word. First of all, of course, at the EU level, we are sure that we need to continue to work for some international solutions, and not only in Europe. And this is the reason why we have given a huge support to the International Criminal Court, because we are sure that there are some things to do more and more with the ICC. But it's not a reason why there's nothing to do with the national jurisdictions, and we are working with many national jurisdictions. I want just to insist that we try so to facilitate the work in the EU first, because we have such a responsibility with the way to collect evidence and to ask to some other member states to collect evidence with the European investigation order, or to facilitate some other processes with the European arrest warrant, or with the judicial network, with a good cooperation among member states. And in the future, we try so to work with a new instrument to facilitate a transfer of proceedings between member states, or sometimes with third countries. To be very concrete, there are discussions with Ukraine to see if it's possible to transfer some proceedings from Ukraine to some member state. There are discussions ongoing, also with Germany for the moment, to do that, because it's maybe easier to organize the trial in another place than in Ukraine for some kind of case. And so we are working on that. But I want just to add one thing. We have many beautiful declarations about the need to go to a judicial cooperation, but the Prosecutor of Bosnia and Herzegovina have explained that not so far that now, 30 years later, we have till now some difficulties to have a good collaboration with quite neighboring countries. I don't want to repeat what you said about the problem with some kind of procedures, but we continue to work on it. And you know that in the UN there is a residual mechanism to continue to work on the genocide in Rwanda or the war in former Yugoslavia. And at the EU level, we try now to convince member states sometimes, candidate countries, to take part in the process. And not just to speak about Ukraine, to speak about other kind of situation in the world, but at home to do the job. So there are a lot of things to do, to convince sometimes to be very active. And I know that with the Prosecutor General we try to do that, but we have mentioned Serge Brummers, who was now in charge for the UN. With him we try also to do the same, to convince sometimes also member states of the EU or candidate countries to take part in the process.
Thank you, and I think that's a fitting end to our panel to just recognize that there is a lot to be done, there is a lot still to be said. We will not be unemployed for a very long time, but it's encouraging to see that there is so much work ongoing and so much dedicated effort out there. And in this panel we have tried to have a discussion on how we can step up the fight against impunity, and we have tried to give you sort of a 360-degree perspective, EU level, national level, global level, civil society, and I'm sure that this conversation will continue in other fora. To wrap up, I think that we realize that this is a multi-layered approach is needed to fight impunity. We also realize that this is a long-term effort and that we have to do this together. No one can stand alone in this. I hope that this conversation has been inspiring for you in your efforts going forward with the work on the convention for the next few days, and that you have been given some new insights thanks to the panelists. And I want you to join me in a big round of applause for them for being here and sharing their experience. Thank you, all of you.
That brings us to the concluding remarks of the 8th EU Day Against Impunity. Also, my personal thanks to all the panelists for your excellent remarks and interventions and presentations, and to you, Anna-Karin, for excellent chairing of this panel. But a few takeaways from what we heard today is that it's impossible to fight impunity and to ensure accountability without appropriate legislation, both on having crimes in your penal code, but also jurisdictional provisions. We heard what was possible or what would not be possible without universal jurisdiction provisions. We heard how important it is to have specialized staff or dedicated staff within the specialized units who know the complex environment of international law and its interplay with national law. We heard how important it is to have resources available to do these crimes and to have long-term commitment in that way. We heard another factor of having coordination and cooperation between national authorities, between international bodies, on sharing of expertise, sharing of experience, but also of jurisprudence. We heard that it's essential to have political support and political will of government, of parliament, to actually ensure those resources, to ensure appropriate legislation. And we need to have a coherent international justice ecosystem with cooperation with civil society organizations, both local, international, regional, and in that way on kind of more political level, but also concretely with the example given, with prosecutors' offices, with investigators as well. We also need ecosystem that ensures cooperation between civil society organizations, national authorities, regional bodies, international tribunals, and court. So all these are sort of essential factors that we can have successful fight against impunity and that we can ensure accountability for the most horrible crimes and to be sure that we can deliver justice to victims. Many thanks to all distinguished guests, many thanks to the audience, and also many thanks to our online participants. With this, I will conclude the 8th Day Against Impunity, that I am sure that together we will have success in the future in fighting these crimes and ensuring accountability. Many thanks.